Melbourne town where the suits all grind. There's a lawyer with a vision, one of a kind. He's the Aussie Overlaw'd. He'll fight for your rights, and he's got his own channel shining bright. From the courtroom to the web, he's got it all. Sharing legal knowledge, answering the call. He breaks it down in a language we all understand. The Aussie Overlaw'd taking a stand. With his Aussie charm and his legal know-how, he's the hero we need, showing us how. He fights for justice, no case too tough. The Aussie Overlaw'd.
And good afternoon, good evening, and good night, and welcome back. I decided to do an evening stream because we have an hour and a half or so left of Dr. Retrial on the stand. So, given that I'm trying to catch up, basically, it was either that or do it in the morning, which then meant that I'd have to run around and try and work out what to do in the afternoon. Whereas, depending on how things play out, depending on when closing statements are and that sort of thing, I may even get to take a day off. I highly doubt it, but we'll see exactly what happens. So where are we? I think we just come back from lunch, and we were like 10 minutes into Retrial after lunch. So let me just double check that I've got the playback speed set properly, and we'll get stuck straight into it.
But yes, for that one comment there, those were the three that...
Oh, hang on. I'll duck back just so we can hear the question.
Yes, sir.
Of those three sites. And when you cited 24, 25, 26, did any of those three sites, in fact, those are the only sites that you cited for that proposition, correct?
Yes, sir.
So your entire basis of sites is limited to those three articles or three papers, yes?
For reference, it's not, the testing obviously proves differently, but yes, for that one comment there, those were the three that were provided, yes.
Starting with number 24. When you looked at 24, did it ever suggest, this paper, did it ever suggest that it was appropriate to use a crash test dummy in the material of a crash test dummy to make an analysis or determine whether or not there would be documented damage to someone's skin?
No, it didn't, and that's not what I did in this matter.
In this article you cite supporting the claim that you made, there is nothing in here that would suggest that a crash test dummy is appropriate to use in making that determination, is there?
There is not, no, sir.
In fact, in this article, it gives you details on what actually should be used to make that analysis, doesn't it?
No, sir. It tells you certain ways to look at sharpness and how lacerations are caused.
This is titled Skin Tissue Cuttability and its Relation to Lacerations Severity Indices. You know that, you cited that.
That's correct, and it looks at specifically, I think, laminated glass and its ability to cut the skin.
Number 24 in your site, correct?
Yes.
And it tells
If the defense is rested and he said no rebuttal witnesses, I mean, look, it would be extremely irregular. But at this point, I'm pretty sure that Hank's understood the lay of the land, and at this point, you just got to try and cut your losses at this point, Hanky boy. If I'm perfectly honest.
tells you 3 types of skin were examined and used for this type of study. Post-mortem human skin from 2 different body sites, Cameo's leather, and Napa goat skin. Is that correct?
Right, to look specifically at laminated glass and it's the cutability of that type of glass.
And the reason why the study is giving those suggestions is because a crash test dummy's arm and fabric, the way it's made, is different than how real skin would respond. Yes?
Well, it is different, sure.
Yeah.
And I didn't do that type of comparison.
You did not do any comparisons with any of the suggestions in the site that you cited in support for your proposition, did you?
Oh, I did not evaluate that. No, not in that manner. No, sir.
And then you cited number 24 or 25. You cited a book, Forensic Pathology, correct?
Correct.
And in this forensic pathology book, in the entire book, it never suggests that crash test dummies are appropriate to use when making this type of analysis, does it?
Correct. And that's why I would not do that type of analysis with respect to lacerations. That's not what my analysis involves, sir.
My question was, nowhere in that book does it say that crash test dummies are appropriate for analyzing skin lacerations on a collision, does it?
Sure. I mean, for that sake, it doesn't say it's inappropriate either.
And then you also cited an article, your third article, Understanding the Acute Skin Injury Mechanisms Caused by Player Surface Contact During Soccer. Did you cite that?
I did, yes.
And again, there's nothing in there that talks about the appropriate use of a crash test dummy when you are trying to support the proposition that someone's arm is consistent or inconsistent with producing cuts and damage in a collision.
That's correct.
Are you aware of literature relative specifically to the use of the hybrid 3 crash test dummy, which was used in this case?
There's a lot of literature with respect to the hybrid dummy, yes.
Have you ever heard of the person by the name of Stanley Bakatis?
I don't recall that I have.
Okay. How about Harold Mertz? Isn't he a leader in the field with crash test dummies?
He is, yes.
Would you agree that we also do not believe the current instrumented arm configuration is suitable either for prediction of soft tissue injuries? Would you agree with that?
Well, for laceration, sure, it shouldn't be used for that. It shouldn't be used in that manner. That's why I don't use it in that manner.
Do you have any source that says it's suitable for determining superficial abrasions?
I do not, no, sir.
You have no other sites whatsoever supporting that proposition, which led inevitably to one of the opinions you gave to this jury, true?
No, not true. That's a misrepresentation of what I performed, the testing that I performed, and the results that I analyzed in this case.
Now, you've talked a lot about Dr. Welcher's pain test. You don't have any information that Dr. Welcher ever claimed that his test was intended to represent exactly how Mr. O'Keefe's arm was when he was hit, do you?
Well, the evidence I have for that is that in his report, he says that the orientation and position of the lacerations are consistent with the orientation position of the tail light cover. And then right under that, he has reference to that test that he performed. So again, if he didn't intend to do that, then there's no evidence that he can provide with respect to the arm impact at all. That's the only test that was performed to look at the arm and the tail light cover. If it doesn't represent the actual position, then apparently he has no idea how the arm was positioned or how it was impacted.
Let's get back to my question.
Yes.
Is there anything where Dr. Welcher has informed you or written that he is intending to represent the actual arm angle of John O'Keefe when he was hit by Alexis?
Again, I just described what he has in his actual report. So he didn't write specifically that that's what it's intended to do. It seems he's inferred that. And again, that's the only test that he's performed or referred to in this case.
You inferred that.
Inferred that that's how he believes that the arm was positioned.
I think we understand your perspective is that it's the only test he performed. But what I really want to get at is your conclusion, your assumption that Dr. Welcher was suggesting that there was a specific arm angle that occurred in this case that he was identifying. You don't see that anywhere in his report.
Well, it would be pretty odd if the one test he ran didn't actually represent what he thought happened. I don't understand what the value of that would actually be.
Did Dr. Welcher ever represent that he was trying to describe the actual body position of John O'Keefe when he was hit?
Actually, he doesn't state that. He states very little in his report or in his PowerPoint. He demonstrates through the video of his arm like that and contacting it, and then he holds his arm up to a picture of Mr. O'Keefe's right arm to compare and apparently demonstrate.
No, I decided to do an extra stream to catch up. This is about where I finished with today's stream, so this is all brand new to me. I can't believe he's actually impeaching his own witness at this point in order to try and score points. What a dumbass.
that it's in the same area. But again, he doesn't actually state that opinion. He doesn't state any opinions that the contact actually occurred, except in one point, and has no evidence or foundation for that.
Would the answer to my question be no?
You would have to ask Dr. Welcher, I suppose, but if it's not, again, then I'm not sure what that test actually accomplished
Well,
or
I'm asking
represented.
you. You've made assumptions and then have given opinions to this jury based on your assumptions, haven't you?
I've evaluated the evidence in the one test he ran. If that's incorrect, well, then I would have to correct my opinion and my assumption and say that not only is the test not actually show what occurred, but he hasn't performed anything to actually link the arm contact to the taillight cover. If it doesn't represent that, you're right, I'd change my opinion that there's no evidence, no analysis, no conclusion whatsoever.
I'm going to try to make my question a little clearer. Is there anything in the report where Dr. Welcher has stated that the arm angle in the demonstration was in any way attempt to replicate exactly how John O'Keefe's arm was when he was struck by Alexis?
I don't believe anything's written in the report with respect to that, no.
Is there anything in the report, Dr. Welcher, anything, that states Dr.
So then what fucking good was he? You've paid him $425,000 for jack shit. If the one test that he did doesn't actually relate to how John was hit or what he was actually trying to prove, then his entire report is useless.
Welcher was stating or claiming that he knew the body position of John O'Keefe when he was struck.
I'm going to allow that.
So no, I guess there is no opinion or conclusion that he knows how Mr. O'Keefe was actually positioned at the time of this alleged incident.
You
You're
know
correct.
whether Dr. Welcher has been clear that he does not know? Let me say this differently. You would agree, Dr. Welcher has never stated in his report that he can identify the speed at which Mr. O'Keefe was struck in a collision.
He does not state what he thinks the speed is. That's correct.
He never states how far, if at all, Mr. O'Keefe was thrown after being in a collision.
No, because he made no conclusions about that whatsoever. And you're right. Why is the UU not working? Hang on.
That's right. He does not.
When you don't know the speed, you don't know the body position, and you don't know the angle of the body at the time of collision, you cannot replicate a collision with crash test dummies to a reasonable degree of scientific certainty.
Well, you're right. You can't prove that that actually occurred. That's the basis. Yeah.
So,
If you don't have the
You can-
information, you can't replicate what happened. You can't determine, you can't state to any conclusion of accuracy what actually occurred if you don't have the evidence.
so if you were to do a crash reenactment, but couldn't state to a reasonable degree of scientific certainty this replicated the actual collision, that wouldn't be scientifically reliable to a reasonable degree of scientific certainty, would it?
Well, if you perform a test and you state this is what I tested and this is the angle, then you can certainly say these are my conclusions. But if you don't know the throw distance, if you don't know the position, then you're correct. You can't actually come to a conclusion that it didn't occur. If you don't know how something occurred, how can you conclude that it actually occurred? It scientifically makes no sense.
Pretty straightforward.
So, if an expert does a crash test and they can't determine to a reasonable degree of scientific certainty that it replicates the actual collision, you would agree that would not be a reliable test to present to a jury, don't you?
I'm going to, very briefly.
He's actually impeaching his own witness just so that he can try and score some points. At this point, I feel like he knows he's going down with the ship and he does not give a shit.
In reading the reports and evaluating the PowerPoint, would you agree there is no statement by Dr. Welcher ever in anything that you reviewed that he is claiming or stating that his paint test was supposed to be a reenactment, identifying the details of how Mr. O'Keefe was standing, moving, or holding his arm at the time of a collision?
He did not state that. That's correct.
So when you've made your criticisms, that you've done testing regarding Dr. Welcher, you don't have any evidence, any statement on it that he was trying to reenact the actual collision.
When I did that, there was one test with the arm like this. That's the only evidence that was presented in his opinion or in his case. I evaluated that. I have not seen any other explanation of what happened or how it occurred. Specifically, Dr. Welcher said in his report on page 9, he said, I have conducted an accident reconstruction and biomechanical engineering analysis of this matter. If he did not recreate how he was positioned, if he did not determine the speed of impact, if he did not determine how Mr. O'Keefe's body moved, if he did not determine where he ended up, then he did not conduct either an accident reconstruction analysis or a biomechanical causation analysis. He did nothing of the sort.
Damn.
Other than your opinion, let's get back to my question if I could.
Objection.
I believe I answered at the beginning of that, sir.
I'm going to ask you again. My detailed question is, there is nothing in Dr. Welcher's report or any of his presentation that states he is trying to represent the exact posture, movement, and stance of Mr. O'Keefe when there was a collision. It's not anywhere in there where he stated that.
It's not stated. I'd be curious to find out what that, if that wasn't the intent of the test, I'd be curious to see what the actual intent was.
Is the answer no, it's not in there?
I think I just said that at the beginning of my answer, sir.
I'm going to ask you again, is the answer no?
The answer is no.
When you do crash tests, you have a controlled environment in some respects, don't you?
You do, yes, sir.
You get to control some or sometimes many of the variables, don't you?
You can, yes.
Real life sometimes is described in your world as chaos, right?
I suppose it could be under certain circumstances.
Testing is limited to the variables that you produce, but real life sometimes has variables you can't predict. Isn't that fair to say?
It's possible, yes.
Is it more than possible, doctor?
I don't know, is it?
But I'm asking you.
It depends on the situation and the certain variables. It depends on the case. It could be possible, yes.
Have you seen cases where the variables are impossible to predict?
Where the what?
Variables. Have you had cases? You've had many cases, you said. Have you had cases where variables are impossible to predict?
It depends. I mean, it depends on what you're looking at. And
My detailed question is, there is nothing in Dr. Welcher's report or any of his presentation that states he is trying to represent the exact posture, movement, and stance of Mr. O'Keefe when there was a collision. It's not anywhere in there where he stated that. Is it?
it's not stated. I'd be curious to find out what that, if that wasn't the intent of the test, I'd be curious to see what the actual intent was.
Is the answer no, it's not in there?
I think I just said that at the beginning of my answer, sir.
I'm going to ask you again, is the answer no?
The answer is no.
When you do crash tests, you have a controlled environment in some respects, don't you?
You do, yes, sir.
You get to control some or sometimes many of the variables, don't you?
You can, yes.
Real life sometimes is described in your world as chaos, right?
I suppose it could be under certain circumstances.
Testing is limited to the variables that you produce, but real life sometimes has variables you can't predict. Isn't that fair to say?
It's possible, yes.
Is it more than possible, doctor?
I don't know, is it?
But I'm asking you.
It depends on the situation and the certain variables. It depends on the case. It could be possible, yes.
Have you seen cases where the variables are impossible to predict?
Where the what?
Variables. Have you had cases? You've had many cases, you said. Have you had cases where variables are impossible to predict?
It depends. I mean, it depends on what you're looking at. And if you want to conclude that something happened and this is how it occurred, you have to look at those variables. If you can't control for those variables, then it's possible you can't prove that it actually happened. So yes, if you're doing a certain test to prove something, you have to look at how those variables may affect it. But there's basic information you have to know to perform that type of an analysis.
So my question again
Mommy
is, are there
milker.
scenarios where variables are impossible to predict?
There could be, yes.
Have you had cases yourself where there are variables that were impossible to predict?
I suppose I probably have. I mean, it depends. If you don't know what happened, sure, then you don't know those variables necessarily.
How many cases have you done on pedestrian accidents?
I've done hundreds of cases.
So you have a good background and basis to know whether or not there are variables that sometimes you can't predict, don't you?
Oh my
Sure,
God.
as I said, it depends on the
You're not
case.
gonna
When you did the crash tests in this case, did you actually do them?
I did not, no.
Were you even there when they happened?
I was not, no, sir.
So you're relying in part on Dr. Wolf's work.
I haven't had a chance to.
I am,
add
yes.
you yet.
If Dr. Wolf made mistakes, would that affect your conclusions?
It depends what mistakes they are.
When you had, or when Dr. Wolf had the crash test dummy in test E and F on a forklift, do you remember those?
I do, yes.
When it's on the forklift, it does not allow the crash test dummy after being struck to move, to be thrown, does it?
Actually, if it's a force acting on it, it will move. It will like a pendulum. So if there's a force acting on it, you'll see which direction it moves. If there's a forward force, it will move. It'll swing forward or sideways or backwards. It can move.
Well, my question isn't direction. It's can it show the throw? Can it throw or move the crash test dummy in its natural course after the collision to a resting spot?
No. In those tests, though, there wouldn't be any throw.
If a crash test dummy is restrained by a forklift, if a crash test dummy is restrained by a forklift, it does not allow the crash test dummy to be thrown, does it?
Assuming there is throw, that's correct. It doesn't.
It doesn't allow an observation of the crash test dummy to turn or fall, does it?
No, it does not. Well, no, actually, it turns, sure. I mean, it can spin.
How about fall?
No. And a crash test dummy would just fall down. And
Have you seen crash test dummies where it is held in place electromagnetically, and when the collision happens, then the dummy can move? Have you seen that?
I have, yes.
Have you seen, excuse me, have you seen crash test with crash test dummy where there is a light? I'm sorry. Have you seen crash test with crash test dummies where there is a light string and somebody cuts the string moments before the impact or a second before
I
the
have,
impact?
yes.
That wasn't done in this case, was it?
What? It wasn't necessary.
Was that done in this case?
It wasn't. I'll speak slower, a little clearer.
If you answer my question.
I just did answer it. I said it wasn't.
When the crash test dummy is held by a forklift and the car hits it, it doesn't replicate the drag that the car will have on the crash test dummy as it would a real person, does it?
You can see if there's any drag because it's on like a pendulum. So if there's any drag pushing it forward, it's going to sway that way. It's going to move the dummy. It's not going to move at the distance that it actually would. If there was any distance, it would move it. But you can actually see the motion. And you can see in the testing, the 24-mile-an-hour testing, there was no motion, which is not unexpected for that type of a test.
There is a difference between a crash on center of mass and
On the one hand, good on him. On the other hand, I really don't want the jury to be looking at this guy and going, what a smug prick. Because they're supposed to be looking at Brennan and thinking that.
a fender vault, isn't there?
There is, yes.
A fender vault is a different type of collision than a center of mass collision, isn't that true?
That's correct.
It is impossible to replicate all of the different scenarios of the crash test dummy on a fender vault collision, isn't it?
I mean, it depends on what you're trying to replicate, and it depends looking at the injuries or how someone was positioned. So if you know how they were positioned, you can try and replicate that, yes.
Could I have 59 of Dr. Rentral's PowerPoint, please? In your PowerPoint, you cited an article, vehicle pedestrian.
I tried even more. I cried, and I can't recall what for. I pressed, I pushed, I yelled, and begged and hoped of some success. But the inevitable fact is that it never will impress. I've no more fucks to give. My fucks have run dry. I tried to go fuck shopping, but there's no fucks left to buy. I've no more fucks to give. The more fucks I've tried to get. I'm over my fuck budget and I'm now in fucking debt.
Collisions, validated models for pedestrian impact and projection, correct?
Yes.
And you put snippets up on the board?
Yes.
And these snippets talk about an engagement with the pedestrian in the vehicle?
Correct.
Is there a reason why you took out a piece of that article that falls between those two paragraphs?
I don't think so, no. Those were the most relevant parts.
Did you cut out the part that says some frontal collisions are with the corner of the vehicle where the pedestrian is deflected to one side without secondary impact of the upper body with the vehicle?
I'll be honest, I wasn't sure how people would react to that, especially given that, oh, look out, pick your moment or whatever else. I thought that was fucking perfect.
Vehicle front. Alternatively, the transverse velocity of the pedestrian at impact may be sufficient to prevent head contact as the body rotates sideways off the bonnet. And these situations are known as fender vault. The models presented here do not apply to fender vault. Did you leave that part out purposely?
Oh, yeah, I did, sir, because this isn't a frontal impact with a sedan over the fender of the hood of a sedan. This is with the back of an SUV, so it's completely different.
You've cited many, many sources where it talks about front-end collisions because that is the majority of pedestrian collisions, the front end, isn't it?
The majority, it is, yes, sir.
And so there is a difference between fender vault and a center of mass collision, isn't there?
That's correct. And that's why you see a center of mass, you look at the testing we did, that's a center of mass impact. On a frontal impact, usually, if you're hit by the front of a car, it doesn't usually get your center of mass, you're too tall. That's why you do a fender vault, or you flip onto the hood, or you flip over the top of the car. So yeah, it's completely different. It doesn't pertain to allegedly what occurred in this case.
So let me get back to my question. When the tests were done, E and F was a center of mass collision at 29 miles per hour, wasn't it?
That's correct, yes.
Right. E, are you considering E a center of mass collision?
Which was he, the
24 miles per hour.
No,
Good
it didn't hit the center of mass of the dummy, it just hit the arm.
Exactly. So there is a difference. In this case, you don't know the position of Mr. O'Keefe's arm at impact, do you?
Nobody knows. I don't think his arm was even impacted by the car, so no. I don't know the position of the arm at impact because it wasn't hit by the car.
You don't know the angle of his body at impact, do you?
The alleged angle?
So ask the
Dude is not letting him. He is not letting him off the hook. The alleged. I love this guy. I really do.
question again.
Okay. You have no information about the angle of Mr. O'Keefe's body at the time the defendant's Lexus was traveling backwards on January 29, 2022, do you?
We have no information that he was even hit by the Lexus. So there wouldn't be any information on the angle if his body wasn't hit.
When you talked about force equations with this jury, you cited a number of pieces of literature, didn't you?
I did, yes.
When you cited the literature, you cited all literature regarding concentrated forces, didn't you?
No, that's not true.
There's a difference between concentrated and distributed force, isn't there?
Yeah, I talked about that on my direct, yes, sir.
When you showed your slides, for example, the hand,
Yes.
could we see slide 8, please? Okay. Let's try slide 56. You would agree with me, Doctor, there's a difference between a concentrated and a distributed load, wouldn't you?
I would, yes.
When you gave your opinions in this case, it was based on concentrated load, wasn't it?
No, sir.
When you gave your force equations, was that distributed load or concentrated load?
That was the load at the center of mass. And so you can evaluate that on the distributed load. You look at acceleration, you look at bending moment. So you can do both.
When you gave your charts and numbers, was that based on concentrated or distributed load?
No, that was based on the distributed load with respect to the center of mass of that arm and where the accelerometer was.
But this was not a center of mass impact.
We're assuming a center of mass is the most dispersed impact. So if we want concentrated, then we look at a focal point, and you can do that with a hand.
So
But the center of mass, acceleration, and distributed across the entire arm, that's where it's the least amount of pressure, if we're talking about force over area. And that's what I evaluated in this case.
When you gave your demonstration about the hand with the different hexagons on it, do you remember that?
I do, yes, sir.
There was a difference between taking a small object and putting pressure on the body as opposed to a larger, wider object, isn't there?
Well, it depends on what it's contacting. And certainly not a difference when you look at the size of that impactor and the size of the knuckles and the metacarpal bones.
So, for example, if somebody took a book and hit somebody off the forehead, it may or may not leave a mark. But if they use the same force and they took a high heel, the heel of a high heel, and hit somebody, there would likely be more damage with the high heel than there would with the book. Isn't that fair to say?
Well, soft tissue, but if the force is the same, you would expect the fracture to occur. You have to look at the distribution, you have to look at the strength of the bone, and you have to look at the overall force that's being applied.
Now, you said in your differential diagnosis, you considered all evidence. Did you say that on direct examination?
I don't believe I did. I believe I considered evidence for a biomechanical and accident reconstruction analysis in this case.
So you didn't consider phone data.
It has nothing to do with biomechanics or accident reconstruction.
Did you consider text stream data?
I'm going to allow that.
I'll strike it. Did you consider Apple Healthcare data?
No, sir.
I'm going to allow it.
Did you consider phone temperature, battery temperature data?
I'm going to allow it.
Has nothing to do with biomechanics, sir.
I'll ask again. Did you consider it?
I did not, no.
You said it would be improper to ignore evidence. Are those your words?
For a biomechanical analysis, yes, sir.
Have you been to the scene of an accident before or a collision?
I have, yes.
Do you know what a debris field is?
It's fucking well seeming like it. It really is. He is floundering and he is failing. Oh shit, I need the "you are failing" clip. Did you consider the position of Jupiter? I know, right?
Yes, sir.
And you've seen in your videos E and F, there's debris fields after the collision and the taillight brakes, isn't there?
So first of all, there's debris in the yard. What that's from? Is there a collision? Was there a collision? Where did that come from? Where it was positioned? That's all conjecture and supposition. Those aren't actual facts, sir.
Can you hear my question about debris field? I'm asking.
Yeah, and I think it's inappropriate.
Excuse me, sir.
No, hang on. You asked him a question. He's entitled to respond to that. You were the dumbass to put a question mark on the end of that. Can you hear my question? Yes, that is a question that he is allowed to respond to, Hank.
In a collision, have you seen debris fields?
I have, yes.
Have you seen debris fields where a taillight is shattered?
I have, yes.
In fact, in your video, yes or no, after the collisions in video E and F, there are debris fields, aren't there?
There are at a certain point, yes, sir, absolutely.
And so when you're looking at your studies, do you consider debris fields?
It depends on the evidence. It depends on how it was collected. It depends if it is accurate or reliable. But from a biomechanical standpoint, no, you don't need to look at the debris field or alleged debris field of a taillight cover. That has nothing to do with the injuries or the position or the movement of an
Exhibit
individual.
73, please. Do you see that, sir?
I do.
Do you know what that is?
Looks like possibly part of the taillight cover.
Right. Is that an alleged part of taillight cover, or do you think that's part of a taillight cover, sir?
I don't know specifically. It might be part of the actual taillight
Well,
cover.
when you studied this case and you looked at all the evidence and all these different things, did you look at these photos and see that alleged piece of taillight shard recovered from the front yard area of 34 Fairview Road? Did you consider that?
Well, was that part of the one that was recovered by a leaf blower or not?
When you were doing your ample study, sir,
Yes.
what I'm asking you is, when you were looking at all the available evidence, did you look at this photo of this alleged taillight shard on the front lawn of 34 Fairview Road? Were you aware of it?
No. Oh, I was aware that there was debris in the yard, but again, that has nothing to do with the biomechanical analysis. If you can't prove that the impact happened, then everything after that doesn't actually matter, does it? Because all of that would be from something else. So unless you prove the core issue of this case, the contact, the post-impact movement, the head injury, without proving that, everything else is ancillary to what you're attempting to conclude.
Do you have any evidence in your biomechanical studies how this alleged piece of taillight shard ended up on the front lawn of 34 Fairview?
I don't know, sir. I didn't evaluate or investigate that.
Could I have Exhibit 76A, please? Did you see this photograph, sir?
I do, yes.
Is that part of a red taillight shard or an alleged piece of a taillight shard?
It looks like it, yes.
Did you consider this in your biomechanical studies that this taillight shard was found in front of 34 Fairview Road?
Well, sir, can you give me a precise distance from where the body was found and where that was found with respect to Mr. O'Keefe, with respect to a reference point?
Did you consider this, sir?
There was none, so no, I did not consider that.
Do you know how this taillight shard got there?
How it got there?
Yes.
That wasn't part of my analysis. There are certainly different possibilities of how that actually occurred.
Exhibit 990. You know what that is, sir?
It looks like part of the light assembly.
Mr. O'Keefe's hat?
Oh,
Did you
that's
look at
his
this
hat.
photograph?
I see now, yes.
Did you know he was wearing a hat that night?
I did, yes.
And did you consider how that hat ended up on the ground in front of 34 Fairview?
No, sir, that was not part of my biomechanical analysis. There's a number of ways a hat can end up in a yard.
Right. Is one of those ways being in a collision with a Lexus?
I suppose that's a possibility, or someone could put it there. I mean, there's a number of different possibilities as to when or how a hat may appear in a yard.
Who do you think put it there?
Well, I have no idea. I haven't seen any evidence of how it got there, and frankly, it's immaterial to a biomechanical analysis.
Do you have a theory you want to share with us about planting evidence? Is that what we're getting at, sir? By the way, the x-rays you looked at earlier, when's the first time you saw those?
I saw those when I was on the case initially for the first trial.
No mention in your report about reviewing those.
It says I reviewed medical records and reports. That's how I actually word in every report I have. I just put generally that it refers to medical records and reports, which includes x-rays, MRIs.
Exhibit 74, please. Have you seen this photograph?
Bad fucking day.
I have, yes.
Okay. In your studies or your testing, did you determine how Mr. O'Keefe's shoe ended up near the curb?
No, sir.
Exhibit 201A, please. Have you seen this photograph before?
I don't know that I have.
Have you ever seen any container that had taillight shards that matched the defendant's Lexus that were removed from his sweatshirt and his shirt? Have you ever seen any container holding those?
I haven't. Well, I believe there was evidence collected like that, but yes.
Okay, could we have 201E, please? Have you seen this photo?
I believe I have seen that, yes.
Did you understand those are taillight shards matching the defendant's Lexus, the broken taillight?
Objection. Now he's just using this witness he's using this witness as an excuse to retestify and represent evidence.
Yes.
That were recovered from Mr. O'Keefe's sweater or shirt?
Objection. I'm going to allow that. Did you consider that?
I'll try. I'd rather try to reformat than come sidebar. Did you know that taillight shards were collected after Mr. O'Keefe's sweatshirt and t-shirt was scraped?
Objection. I'm going to allow that. I need to see what's jurors, this will be brief.
I've already decided how I'm going to rule jurors, so this is going to be very brief. Okay. I don't appreciate what Hanky's doing here. He's literally reintroducing evidence, basically saying, oh, here's all the different bits and pieces that I believe the jury need to be paying attention to. Did you consider this? It's bullshit. This should not be happening. But let's face it. Hanky's copping it left, right, and center from this guy. Okay, not quite sure why that didn't work, but anyway. Oh, I would pay good money to have seen the juror's face on that. Like, honestly.
In your extensive study of the detail of this case, did you know that these pieces of plastic were removed or scraped from Mr. O'Keefe's clothes, specifically his sweatshirt and his t-shirt? Did you know that?
I was aware that samples were recovered, yes.
Were you aware that these samples were consistent with the broken taillight of Miss Reed's Lexus? Did you know that?
Yes.
Did you do any analysis how these broken taillight shards got into Mr. O'Keefe's clothes?
No, I did not. The first step involved with that would be to actually perform a biomechanical analysis to look at the movement of the body, how the body was positioned, where it ended up. So without that knowledge, you can't determine exactly how or if those types of shards were deposited there as the result of an actual impact.
Based on last question, based on the question that's asked. There's a series of others indicated sidebar. You just need to reformat. Sure. I'll try again.
Okay.
When you look at these taillight shards that were
Objection.
Go ahead, Mr. Brennan.
when you look at these taillight shards that were consistent with the break in Ms. Reed's Lexus, did you consider how they got into Mr. O'Keefe's clothes?
Objection. Same objection.
I understand the objection. Word it differently. Just start with a different one.
Yes, Your Honor. You see these pieces of broken plastic, don't you?
I do.
And you understand that these were found in scrapings of Mr. O'Keefe's clothes.
I do.
And you understand that these broken pieces of plastic are consistent with the taillight of Ms. Reed's Lexus.
I do, yes.
In your studies and reenactments, did you make any determination how these pieces of broken plastic got into Mr. O'Keefe's clothes?
No, when you look at those studies, first you have to know how the incident occurred. Then you can look at that and determine, if you want to, how that may have occurred. Because otherwise, there's, again, different ways, different manners in which that may have been deposited on the sweatshirt. Without knowing how this happened, you can't just then look at other evidence and try and predict how it happened. You need the actual evidence to look at the event. This all goes to the event. You need contact with the arm, I guess apparently, to actually cause this incident to occur. And without that evidence of any of that happening, knowing how the body moved, knowing how it was hit, knowing where it ended up, any conclusions drawn off of information like this is just supposition, because you don't know the movement of the body or the vehicle. It's putting the cart before the horse.
Can I have exhibit 201D, please? Do you understand this is broken pieces of plastic consistent with the broken taillight of the defendant's car? Do you understand that?
I believe so, yes.
And do you understand this is a photograph of these broken pieces of plastic under a microscope?
And do you fucking understand that he is saying you have no basis to ascertain? Wait, isn't that the one that was in the tiny little container as well? Do you understand that he's saying that there's no basis for him to be able to make any sort of opinion on that because it's irrelevant because he was not hit by a car based on the biomechanics? Hank, the more you do this, the stupider you look. Jesus.
Okay.
Well, I'm asking you, do you understand?
So if that's what you're
I don't,
telling me, then
I don't want you to rely on me. If you didn't see them, it's okay.
I don't recall if I saw those or not.
Have you seen this picture?
I don't recall seeing it, no.
Now looking at this photograph and seeing these broken pieces of plastic under a microscope with fibers near the plastic, is that something you would want to consider in your analysis, informing your opinion whether or not it was a collision?
No,
It's relevant analysis.
Again, if you can't do a proper biomechanical analysis, then that evidence is not consistent. You can't determine how it occurred. You can't say that that's consistent with it. You can't just look at certain evidence and not do a proper analysis. If you can't even tell that an impact occurred, you can't look at tertiary evidence and say, well, this proves that it occurred. In order to say from a biomechanical and accident reconstruction standpoint that an impact occurred and here's how it occurred, you have to understand the mechanics and the dynamics before. This could certainly support that finding and those conclusions, but by itself, I don't know of any methodology in any study or peer-reviewed article that says you can just look at alleged evidence and then form an opinion as to whether an impact occurred.
Can you see with your eye that parts of those broken pieces of plastic are sharp?
They look sharp.
Do you disagree? Do you think they're not sharp?
I don't have an opinion as to that, sir.
He did not just say that.
Objection.
Sustained.
If you look at that from behind them, can you tell me whether you think those pieces of broken plastic are sharp? Objection.
I'm going to allow that.
I guess they look sharp. I have no idea if they are or not. It's under a microscope. When you actually put things under a microscope, it looks much different, and it is much different than
Okay, let's go back to
looking at the normal eye.
20E. Perhaps that can help. Not under a microscope. If you pay particular attention to the larger one in the middle, that looks like a shark's tooth. Do you see
Yes.
that one?
Yes.
Do you think, doctor, that some of those appear sharp?
Some of those appear sharp, could possibly cause a laceration, sure, as opposed to an abrasion.
Do you think that any of those could cause an abrasion?
I don't think that you could get a consistent level of superficial abrasions along the entire arm of minimal depth of less than 0.5 millimeter through impact with the glass. To have that minimal force on every part of the arm to only cause superficial abrasions would be highly unlikely.
Do you think some of those sharp pieces, if they were lodged in Mr. O'Keefe's sweater, could cause an abrasion?
It's possible if you had enough punctures and holes in the sweater to correspond with the abrasions on the arm, that would be, I suppose, that could be a possibility.
In your testing, not to belabor it, I'm just going to show you one. I want to show you video E. Could we go to video E, please? Stop. In video E, the arm that is sticking straight out, who determined that angle, Dr. Wolf?
Yes, well, we positioned it just so it would impact in the general area of what was shown in Dr. Welcher's paint test study, which apparently is irrelevant and doesn't show the alleged position of how the arm was at impact. But yes, we positioned it in that manner.
When you say we, did you have input on the positioning of that, or did Dr. Wolf do it?
Well, I had input into how we were going to position it. It would probably be both of us, I would say.
So you and Dr. Wolf chose to position the arm straight out, correct?
In that test, we did, yes.
Is there a glass in Randy's hand?
There's not, no.
A drinking glass? No?
No.
In any of your studies, did you have a drinking glass in Randy's hand?
We did not have a drinking glass in the dummy's hand, no.
And you see when the taillight is shattering, those red things falling down. What are those?
Those are part of the taillight.
Continue a little bit, please. Stop. Did you count how many taillight pieces broke?
We didn't count the taillight pieces. We counted how many punctures or holes there were in the sweatshirt, which was 0.
If you had done this test and changed the arm angle, do you expect the damage would look different as far as the brakes in that taillight?
Well, we conducted a number of tests. It may look somewhat different, sure.
If you conducted this test and moved the arm angle, not another test, this test, but you move the arm angle, do you expect that the brake would look different?
That the brake would look different?
Yes.
It could look a little different. I mean, certainly the brakes looked a little different in the test, but they were comparable to each other.
You do not know how John O'Keefe was standing that night, do you?
Well,
Objection.
No, I'm going to allow that.
You do not know how John O'Keefe was standing that night, do you?
if he was standing, if the impact occurred, then no, nobody knows how he would have been standing.
You would not know what his arm angle was, would you?
No.
You would not know the exact speed of any vehicle that hit him that night, would you?
Objection.
Sustained.
The debris, the broken taillight, is that traveling in a consistent or a different direction?
What do you mean consistent or
Is it
different?
all going in the same direction or is it going in different directions?
No, there's some spread to the debris.
So the pieces don't all fall right in a pile with each other, do they?
They do not, no.
Continue, please. Stop. Do the majority of the pieces land on Randy?
No, they do not.
And so as they fall, if Randy were to fall, many of those pieces would not be among the immediate area of his body, would they?
If the dummy fell right there, no, they would not be.
Now, the dummy can't fall because the dummy is on a forklift, correct?
It's suspended like a pendulum, correct?
And you see in your test that the taillight, at what you say is 24 miles per hour, can be broken without the dummy's knees touching the vehicle. Isn't that fair to say?
That's correct, yes.
You can't tell the full movement and fall of this dummy the way you've set up this test, can you?
Well, knowing the physics, you can certainly determine or estimate where it would be, but no, you could release it and it would fall primarily straight down. It would twist and it would fall down.
Is there something that could affect the dummy if you let it fall? Is there something that could affect its movement after being hit?
Like what?
Like, could its feet be twisted and then hit another object like a curb?
Well, there's going to be very little lateral movement of its feet, but even if it did, then it's still going to fall over right where it is.
Can you continue, please? Can you see the feet, doctor?
Yes,
Are they twisting?
They are, yes.
Is that because of the rotation of Randy after he struck?
yeah, that's the rotation of Randy. And again, yeah, as you said, that's not a normal person because there's no normal force acting on the dummy. We just have it barely touching. So a normal individual, you aren't going to twist to that extent because this is a dummy which is suspended with just a little contact on it.
And after being contacted by a vehicle enough to break the light, could it cause a person to stagger backwards?
I mean, you're making some suppositions here. There's no evidence that would occur in this case, and not if you're spinning like that. You're not going to stagger backwards. First, you're going to spin if you get hit with your arm, as I described on my direct. But is it possible? I can't say it's impossible, but there's no evidence of that.
Could a person stumble backwards after being hit?
Objection.
I'm going to allow that.
What do you mean by backwards? Because you'd be spinning. So what direction is backwards?
Could a person get their foot caught on a curb and sneaker come off and then stagger backwards and fall on their head?
Objection, Your Honor. Yes.
His reaction to that, just he hit the curb, he's not flying to the flagpole. No, that's what I'm saying. I mean, actually, hang on, did I save that footage? Someone drove past Fairview. I can't remember if I bookmarked it or not. Hang on, give me a second. Marks. No, apparently not. Doesn't matter.
I'm going to allow that.
Doctor?
Can you answer that?
I mean, I guess you could somehow predict or have a possibility of almost anything happening. You could say someone could get hit by a car and do a couple of somersaults into the yard. I mean, there's no evidence of that, so it's just supposition. but I won't say it's impossible.
You think John O'Keefe did somersaults in the front yard of 34 Fairview? Is that what you're telling us, Doctor?
No, I don't think he even got hit by the car, sir.
That's not what I'm asking. I've heard that. I'm asking
Yeah.
you who did somersaults in the front yard.
No, there's no evidence of what he did.
Your Honor, to come sidebar quickly before I start.
Okay. Oops.
What an absolute joke. This guy's just torpedoing the side out of fucking Brennan. He really is.
Could I have Exhibit 166, please?
No. At this point, you're just wasting everybody's time.
Did you see this photograph, sir?
I did, yes.
And do you see the cut on Mr. O'Keefe's nose, the left side of his nostril?
I do.
In your analysis of whether there was a collision with the defendant's Lexus, did you consider or know that there was evidence that a piece of glass or a piece of broken plastic was pulled from Mr. O'Keefe's nose?
Objection.
I'm going to allow that. I'm going to allow that.
I'm only going off of what I heard. It's all rumor and speculation at this point, but it would not surprise me if Welcher and the other Aperture guy decided, nope, we're not coming back as rebuttal witnesses. We refuse. Because unless, I mean, it would look really bad if the day of rebuttal he has to issue a subpoena to get his own witnesses to testify. So, yeah.
So, hold on. Let's get an answer, Dr. Mitchell. Your objection's noted, Mr. Jackson.
I was aware there was some piece of material allegedly pulled from the nose, yes.
Allegedly pulled from the nose?
Yes.
Okay. And that alleged piece of material, were you aware that it was perhaps a piece of glass or broken plastic?
Objection.
Are you aware of that?
Your Honor, that's not an evidence. That is not the evidence.
So,
Class.
hold on, Mr. Jackson. Mr. Brennan.
I can reword it.
Okay.
You're welcome. Are you aware of that object that was pulled from Mr. O'Keefe's nose? What material that was?
I believe it was glass.
Did you want to know in your assessment about collision where that came from?
Well, I did evaluate that, and it's actually entirely inconsistent with coming from an impact with the vehicle.
Could we have Exhibit 52A, please? Do you know what that is, Doctor?
All I'm going to say is, Spanky, I really hope that I was correct in my assumption that you were even a remotely decent attorney and you made sure you were paid up front as being a special prosecutor because, damn.
It's hard for me to see from here. I believe that's the drinking glass.
A drinking glass. Do you
Yeah.
know where that is in relation to where Mr. O'Keefe was found?
I believe it was found in the vicinity of where he was found.
And could I have Exhibit 195, please? You recognize that?
That is another photograph of the drinking glass, yes, sir.
197A, please. B. C. D. And in your assessment, did you know that a piece of glass that fit the broken drinking glass was found in the street area in front of 34 Fairview Road?
Yes, sir.
98, please. A little more, please. Do you know what that is, sir?
It's hard for me to tell from
Does it look
back.
like a drinking straw?
Okay, the black, that does appear to be a drinking straw, yes.
Have you seen that before?
I've seen that photograph before.
And do you appreciate that is in front of 34 Fairview Road?
Yes, I believe that's correct.
And sir, in your analysis, in your reconstruction analysis, did you consider the broken glass found there, Mr. O'Keefe's body, the suggestion glass is found in his nose, and that glass that fit the broken glass was found on the street? Did you consider all those things in your reconstruction analysis?
Well, my biomechanical analysis, I did consider especially the glass in the nose, yes, and whether that could have been as a result of the impact.
A result of what?
a result of the impact with the vehicle.
When did you find out about the glass
That's not a win for you.
from Mr. O'Keefe's nose? When did you learn that?
I don't recall specifically.
But was it before you came and testified last time, or was it before this time?
I honestly, I couldn't tell you. I know it was before this time. I don't know when I found out about it.
Weeks ago, months ago? Could you turn the lights on, please?
I have no idea, sir.
You don't know if it was weeks, a month ago?
I don't remember with that specific piece of evidence when I found out about it.
What do you mean you don't remember it? Have you seen it before?
Well, I evaluated certainly for my report for this case. I don't know if I'd known about it prior to that.
Is it mentioned anywhere in the report about the piece of glass in Mr. O'Keefe's nose?
No, it's not.
When you received that information, did someone tell you about it? Did you listen? Did you watch? How did you evaluate this evidence?
It might have been in an interview or something that it was pulled from his nose, I believe.
Okay. So you saw and listened to something?
I believe so, or was made aware of it.
Okay. Just a couple more.
To be fair, I think Walter was pretty instrumental in destroying his own career. Not on the stream, it's something we'll find out after the fact. Also, so allegedly that's actually happened? Oh, shit.
Question, sir. I had asked you at the beginning of your examination whether you denied that receiving information certainly helped prepare to understand what was going on during the trial. Do you remember those questions?
With respect to the trace DNA, correct?
Okay. May I approach?
Yes.
Yeah, you missed the answer.
April 20th, 2025. Yeah. Page 124, line 16. Yes, 124, line 16. May I approach?
Yes.
You've testified a few times under oath in this case, haven't you?
I have, yes, sir.
And you testified recently for a short bit in April, didn't you?
I did, yes.
On April 28, 2025, did you testify in this very courtroom
I believe I did.
under oath,
Yes, sir.
like the oath you took today?
Yes, or yesterday.
Now, when I read this, I'm not attributing this in any way to the defendant's attorneys. I'm going to read you this just for clarity.
Allegedly, and I say this just because I haven't personally verified it, but he was supposed to be called as a rebuttal witness. Him and the other Aperture guy hopped a plane and said, "Fuck this, we're out." And according to Swamp Bear, sent a text message saying, "Thank you for destroying my career." I can't verify that. I can't. Well, to be fair, I can't verify any of it. But Runkle ate a ham sandwich for dinner on his stream. Based. I was going to grab one because I had to stop to get petrol, and the new roadhouse that's in town that has the gas pumps now, like they've got like it's actually a really nice restaurant in there, and they had like sandwiches and stuff pre-made, and I was like, probably should have. Rebuttal witness. Sure, I had a sandwich. Shoot. See, okay, you know what? Now I feel like I need to go and make a sandwich.
You were asked, did they inform you about witness testimony?
You know what? Screw it. I've
What
got
did you
time. I
say,
gotta get a
sir?
sandwich.
They did inform me, yes, about testimony and situations and events that came forth in the trial that I was not aware of.
Those are your words?
Yes, sir.
I'll be back. Get a sandwich.
Page 125, line 7. I'm going to ask you if this is your sworn testimony, sir. On page 125, line 7, I'll read the question, and if this is your answer, you should give the answer. Were you asked, and by calling and raising issues and telling you information, even if you weren't requesting it, it helped prepare you for your trial testimony, didn't it? What did you swear?
I said it certainly helped prepare me to understand what was going on during the trial, yes.
I have no further questions.
All right, Mr. Jackson?
Yeah, first read the
Okay.
inquired.
Yes.
Thank you. Dr. Rentschler, you were just asked a couple of questions about they provided information about the prior trial, correct?
Correct.
They is no one associated with the defense team, correct?
That's correct. No one associated with you, and they provided information. And again, it let me know what was going on, but it didn't affect my preparation or my opinions. It in no way changed any of my opinions or what I testified to.
Thank you
So
for that.
to get through this, I'm going to let you just
you.
answer the question.
Sorry,
And-
Rob.
And with regards, and I appreciate that, Mr. Brennan asked you a couple of questions about they being your employer. Do you remember those questions at the beginning of his cross-examination?
I do, yes.
Who is your employer, actually? The actual employer that you work for?
ARCA.
Okay, wasn't them.
No,
It's a client, correct?
it was a client.
A
That's
completely
correct.
separate entity that hired you for that work, correct?
That's correct, yes.
Thank you. You were asked about a fender vault collision, and you said, well, this wasn't a fender vault, right?
Correct.
What is a fender vault?
A fender vault is when you're hit by the front of a car and you're moving across the car. So you're moving across the center
I went fancy. Ham, cheese, and onion relish.
towards the driver's side of the car, and the car hits you. You go up over the car and you fly over the fender to the driver's side of the car. So you vault over top of the fender.
Dr. Richler, where is my, as I stand here, where is my center of mass?
Right about your belly button.
Right there.
Yes.
So what would happen if I was hit by a vehicle, front of collision, and the vehicle struck me below my center of mass?
It's going to flip you. Your center of mass will go. You'd go right up. If it was coming right at you and it hits you at your legs, you'd flip right into the hood or over top of the top of the car.
Is that what's described in the industry as a fender vault?
That is part of a fender vault, yes, but it's at an angle. So instead of going direct back, it's because if the person's walking across and you get hit, you fly kind of back and over the top of the fender.
Did that set of circumstances, physics, have anything to do with your analysis in this case?
No, none whatsoever. The profile of the car is completely different. The back of the SUV.
You were asked several questions about the debris field in the test F as in Foxtrot. Well, actually, you were asked about both test E and test F. Test E being the 24-mile-an-hour impact to the right arm of Randy, correct?
Correct.
And test F, the full rear impact, center of mass impact, correct?
Correct.
You were shown several photographs, exhibits of very tiny, tiny shards. Do you remember that?
I do, yes.
I'll get to that in a second. You were also shown some photographs of pieces of plastic that were claimed to have been found at 34 Fairview. Clear plastic, piece of red plastic, correct?
That's correct, yes.
In your review of all the data in the
Oh, damn it! I was looking for the aperture thing for Mufasa, and this popped up. Breaking! New aperture reconstruction video just dropped.
this case. Do you know when
Kimmay said for more
those
ham
pieces of plastic
sammies
got
at the
to 34
Roadhouse.
Fairview?
Sandwich.
I do not.
Thank
No.
Do you know
Very
how
much appreciated.
those pieces of plastic got to 34 Fairview?
I do not know.
Do you know who put those pieces of plastic at 34 Fairview?
I do not.
Were you aware in your review of the police reports that none of the plastic that you were shown was found at the time John O'Keefe's body was discovered and the area was initially searched?
That is correct, yes. I was aware of that.
You indicated that the cut on Mr. O'Keefe's nose, the right side of his nose, was inconsistent with coming from a vehicle, correct?
Correct.
Can you describe why you came to that conclusion?
Well, if you're standing at the back corner of the vehicle and it strikes the arm, and let's be clear, if nobody wants to say where the arm was or how it was positioned, if they're claiming the abrasions are a result of the fractured taillight, it has to strike the arm. You have to be standing like this. The debris goes forward with the vehicle. So it's with your arm like this, it already passes by the person. And if there would be any contact whatsoever, it would be with the right side of the face. The shard can't come out and then make a right turn and then somehow embed itself on the left side of the nose. That's entirely inconsistent with the fracture and how the glass and the cover would actually move.
Dr. Retrial, you were asked a series of questions about a hat. Do you remember that?
I do.
About some shards of plastic material, correct?
Yes.
About a drinking glass?
Yes.
About a drinking straw?
Yes.
Doctor, if there was no collision, does any of that matter in terms of your biomechanical analysis and your reconstruction in this incident?
It does not.
Stingy said, "Can I has a crustless toasted ham/cheese daddy?"
There's some Uncrustables in the fridge.
Why?
Well, because if there wasn't a collision, it wasn't that debris or those items weren't a result of that impact. You can explain how that got there, I believe, easier than if you can't explain how the impact occurred, if the injuries don't match up. If you can't even prove what happened, then you can't use information or evidence if you have no idea how it got there to try and prove what you don't even know what happened. Scientifically, it makes no sense.
Scientifically, is the first question that has to be answered is, was there a collision? Objection.
Sustained, you have to watch the family question.
Of course. In your expert opinion, based on all of your review of all of the data in this case, all of the testing that you've undertaken, do you have an opinion as to whether or not there was a collision with John O'Keefe?
I do.
Yeah, I'm sustaining that, Your Honor.
You honestly think any sandwich I make is going to be any less soulless?
In your view,
You're not getting any of my relish.
was there evidence of a collision with John O'Keefe?
Sustained.
In your opinion, were any of the injuries that you saw suffered by John O'Keefe consistent with having been struck by the subject Lexus?
No, they are not.
Do you hold that opinion to a reasonable degree of scientific certainty?
I do.
Thank you.
And Brennan's face goes up in flames. Or down like a hamster.
Doctor, you just said that you do not believe that there was a fender vault collision. Could it have been a clip?
Could it have clipped Mr. O'Keefe?
Yes. Not hit him, but clipped him.
Well, I don't believe that's consistent with the evidence and what occurred. I mean, someone can get clipped by a car, sure, but in this case, no, I don't believe the evidence indicates that's what occurred.
The glass. When you learned of the information of the glass in Mr. O'Keefe's nose, when do you think it was that glass was pulled from his nose? What date?
I think it was the morning when his body was discovered.
January 29, 2022?
Yes, sir.
Somewhere around 6:15 a.m. Is that your understanding?
Sometime when his body was discovered, that's correct.
Do you know or understand that, did you see any evidence that Mr. O'Keefe had a drinking glass outside of 34 Fairview Road that morning after he got out of the defendant's Lexus? Do you understand that?
What do you mean evidence?
Drinking glass. Did you hear anything about that in your review about?
What evidence would there be? Is there a video or a photograph, you mean, of him holding a drinking glass? Because otherwise there's a drinking glass there, but there's no evidence that he had it.
Okay. Judge, can I come sidebar?
Okay.
Dude just destroyed any hope that Brennan had whatsoever. At this point, the only way that she gets convicted is if it's a complete and utter stitch up and it's completely rigged and fixed. So I'm sure that they'll appeal the conviction. Oh, it's a long one too.
You were asked about whether or not any plastic taillight shards were found near Mr. O'Keefe's body. Do you know the limits of the search that the Canton Police Department did around Mr. O'Keefe's body? How small of an area they searched when they first went there?
Oh,
I do not know, sir.
Did you ever see a video of somebody with a leaf blower blowing snow off the ground?
I did see that, yes.
And did you see the confined area in which that happened?
Well, I mean, I saw the area where he was blowing with the leaf blower.
Have you seen any information or evidence whatsoever that the pieces of taillight that were found after that search, have you seen any evidence that they were found in that exact area, or were they found in different areas on the lot?
I'd have to go back and look. I don't recall specifically.
And so when there was a snow blower or a leaf blower search in that area, there would not be a piece of plastic taillight to find if it was never there.
no, I know that, Swamp Bear. I'm saying that I believe that it's rigged anyway. Even with all this, I still genuinely believe that there is a real chance that Karen gets convicted because of how much corruption is involved in this.
Did he?
If it wasn't there, you wouldn't find it? Is that what you're saying?
That's what I'm saying.
Sure.
Okay. Did you notice in the injuries to Mr. O'Keefe, most of them are on the right side of his body?
Well, we have the abrasions and then a 0.5 centimeter abrasion. And then we have the laceration itself on the left side. And then the skull fracture, it's a little bit to the right, but it's mainly on the back of the head.
And the bruise on his knee?
That's the 0.5 centimeter. It's not a bruise. It's a 0.5 centimeter abrasion, about an 1/8 of an inch.
When you're conducting an investigation or you're doing your analysis and you keep saying the physics and the physics, do you add a little bit of common sense in the equation when you're considering the evidence?
Well, you can sit back or step back and look at whether what someone's claiming makes sense in the bigger picture.
So when you have common sense and you look at the big picture, it's not just physics. It's considering all
Oh, come on. If we were considering common sense in the bigger picture, this trial would have been thrown out weeks ago.
of the evidence, right?
Well, it depends what you're looking at. Certain parts of it, the biomechanical analysis, you look at the physics. It tells you what it is. I mean, if you don't like it and you don't think it fits, well, sorry, it is what it is. That's the science. So you have to step back. I mean, you can look at it the bigger picture if things make sense. You know, if somebody was standing on the side of the road with their arm like this while an SUV backed up at them and they didn't flinch or they didn't put their arm up, that's kind of the smell test bigger picture. That doesn't make sense. But the physics, you can't deny it. You have to accept what science tells you.
You can't deny it. That's the line you were laughing about in the documentary as one of your answers that you were all celebrating, isn't it?
Objection.
Isn't it?
The objection sustained.
How'd that taillight break, sir? How'd it break that, man?
I don't know. There's no evidence of how it broke.
Thank you. No further questions.
All right, you're all set, Dr. Wrenchman.
Thank you, Your Honor.
Is there an objection? So, subject to us discussing it. Mr. Jackson? Mr. Jackson? Subject to me taking a look at it and us discussing it. It's not coming in right now. Okay. They've been marked for identity. Jurors, I want to see counsel for a couple minutes over here.
Getting closer.
Jurors, we're going to release you for the day. We will see you tomorrow morning. Those same cautions, please do not discuss this case with anyone. Don't do any independent research or investigation into this case. If you happen to see, hear, or read anything about this case, please disregard it.
Blood pressure's
and let
all
us
right,
know.
mainly
We'll
because
see you tomorrow.
my blood pressure's all right, mainly because that guy just wiped the floor with Brennan. Like, to the point where he opined and went back and clapped back at Brennan on things that he really had no involvement in whatsoever, which I think is hilarious. Because Brennan's the one that walked him into those questions. This is where the fuckery of Brennan happens. Oh, shit. At this point, I think they just want someone to blame, and they don't want it to be the Alberts.
All right, so Mr. Brennan, I'm going to take a recess. You go ahead and look at that PowerPoint. I'll come back out in 10 minutes regarding the PowerPoint.
All right, to the court, please.
Do it! Just do it!
Court is back in session. You may be seated.
All right, so I had a minute to look at the PowerPoint. Are you in agreement on the PowerPoint?
We're not. I do not want to admit it. I don't think it's substantive evidence.
Okay. Mr. Jackson?
Exactly the substance of this.
Which was not objected to, right? But did he object to the PowerPoint coming in?
It's been well under pressure. I don't know what Mr. Leslie did to the PowerPoint. That's the question. The question is whether this PowerPoint is admissible. There's nothing in it. We've taken out all hearsay, discussion, feelings or thoughts, thought processes. These are all the tests that were completed and done. Exactly as Dr. Moore's PowerPoint is done. This PowerPoint is in evidence. This PowerPoint should be in evidence.
Is there anything in this PowerPoint by way of
Is there anything in this PowerPoint that would give me an excuse to exclude it?
videos that is not already in through Dr. Wolf?
I believe the video of the drop test is in Dr. Welch's PowerPoint. There are most of the videos are included. Oh, no, I'm wrong. Please slow down. So there are the videos are the same, but the videos that Dr. Retrial used because of the side of the case that he was handling, the biomechanics side of the case that he was handling, slowed down significantly to show the deformation of the arm, the force impact on the elbow, the hand, forearm. He testified. So what he did, I remember asking him this before I ever saw the PowerPoint, is there going to be anything different? He said, I use the slow motion cameras more than Dr. Wolf does because I need.
Okay, so I need you to tell me tomorrow which slides specifically answer that question for me. Okay, whether they're in evidence or not, and which ones are not regarding the videos.
Suggesting to talk about just the entire PowerPoint?
Maybe. I'm going to take a look at it. There's an objection before me now,
I know that.
so I have to rule on the objection. So I will take a look at this. Okay.
Okay.
So if you let me know, and if you want to let me know tonight, I can let you know first thing tomorrow. All right.
Have you heard briefly?
Yes.
Very briefly.
Yes.
I am objecting. It's not admissible. It's hearsay. It's a strategic decision. The past introductions have been strategic. The defense did not object to Dr. Welch's. I did not object to Dr. Wolf's, but that was a strategic decision. I'm objecting.
Okay.
The defense objected to Shannon Burgess. Only a select amount of documents were allowed. I wanted the whole thing in. I was precluded properly from producing it because it's hearsay. I'm objecting.
Okay.
There's no hearsay. They objected to certain slides. We took out the slides. They had an objection to the PowerPoint. They should have proposed that objection before we displayed for the jury.
Oh.
We've not seen the entire PowerPoint. It's tactical. It's not strategic. It's tactical. It's still like it's a person case. If they didn't want certain things before the jury, which is exactly what admitting into evidence does, brings it before the jury so that they can see it, they should have objected in a timely manner. When they objected, they chose certain slides, certain data on certain slides, and we took all of that at their request and at the court's instruction. We did that with the court's instruction, with the Commonwealth's instruction, and there was no objection to playing before the jury. Given the fact that it's been displayed not in part, in whole, as it now for the jury, for the court, for quadruple for identification, it should be admitted.
Okay.
Just like Shannon Burgess, it's no different.
All right.
PowerPoint is in evidence.
So, Mr. Jackson, when you let us know which slides answer my question about slides that are not in evidence and you want to put in evidence, the videos, just the videos, let me know that. And if need be, I'll hear you all on this tomorrow morning as well. Okay. All right. Is that it for today? Will we see everybody just tomorrow morning? What else?
Mr. Lesson needs to, I didn't interrupt.
After the defendant rests, we will not be calling any witness, putting on any further evidence.
Okay. All right.
There it is. It's officially part of the court record. No, for those of you asking, he cannot pull a Swiftie. That's pretty definitive. What amazed me is with the evidence now, don't the people want to know who did this to John O'Keefe? Will they even look at the dirty cop Brian Higgins? Honestly, I don't know. I fully expect this to be buried, unfortunately.
Your Honor, it's late in the day. We would like to review motion for required finding of not guilty on disclosed of all evidence. It won't be a lengthy argument, but I'm happy to be heard on that in the morning if the court prefers when we got tomorrow morning.
Okay. Is that all we have left now? I have no idea what Mr. Alessi wants to talk about, but would
I'd like to respond to that, Your Honor. And the answer is, given Mr. Brennan's answer with no more witnesses, my issue is moved.
Okay, great. So
The technical thing is we need to move in the 3 items of evidence, the documents associated with the sweatshirt, I think they've been marked for identification.
No, they were marked as evidence, right?
They're marked.
Yeah, they're exhibits.
But no, they're coming into evidence. Your Honor, I mean, ruling is-
Are they,
I thought they were marked as identification, not evidence. They're evidence, they're in identification.
so I need to find that. It would be my intention that they get put into evidence. I'm not going to display them and bring a jury in just to see those at this point.
Not asking for that.
Okay.
As long as they're in evidence and I can use them in closing argument, then should be it.
If I can for clarity, Your Honor, they're exhibits. I have Y.
So that's not an exhibit, Mr. Leslie, if that's how it marked. That's identification.
I have a different parlance. I'll use this word parlance. Yes, it's YYY, ZZZ, AAA, BBB.
So that means that, all right, so that's for identification. Letters are identification, numbers are exhibits.
Your Honor, I understand that. We all know what we're talking about, and Your Honor agreed that they're going to be in evidence.
Right. So, and I've ruled that they're in evidence. I just need to know for this record whether they're in evidence or not. What you tell me, you just told me they're in evidence. They're not. They're exhibits. They're identification. Now they will become exhibits. Can we do that now? Do we have them? Where are they? Oh, Jim, they're in there? Okay.
Yeah, and Your Honor, my whole point in wanting to be heard is that they're not in evidence, and I want to make sure they get it. That's my point.
What number are we at, Madam Court Reporter?
For the 230.
Okay, and we'll do A, B, C, D.
So is it Y, Z, A, and B? I think I have.
Who laminated the hoodie? My understanding is that was the prosecution, and they did it for a very specific reason, so that it was more difficult for certain details, for example, to be made visible. But I have seen that in the past. I fully expected it to be removed from the casing, though.
Counsel, I'm not sure I have those.
All right, so we will make, so as of now, they're in evidence. Tomorrow, we need to physically put the sticker on those.
Can I stick numbers while we're waiting for this?
Yes.
230A,
I'm sorry, say that one more time.
230A versus C, 230C.
All right.
Commonwealth at 4,
Four of them,
A through D.
just so the record, this is limited consent interface. They were marked for identification as triple Y, triple Z, quadruple A, and quadruple B.
Okay.
And all I need to do for my records is figure out which one is which in terms of the whole court's marking. So if we do that, I'm good, I'll get out of here.
We will do that first thing tomorrow morning.
That's all.
All right. We will, so everyone is in
Take the
agreement
5 minutes
then.
to do it now.
I will let you have,
I don't get it. Do you have a tee off time? Is it because it's early bird special at Mimosa Hut? What? Marking exhibits would take all of 5 minutes. Why are you being lazy? Are you hoping that the exhibits will go missing overnight? I'm pretty sure there'll be additional copies.
tomorrow without the jury. We'll have our charge conference here in person, and I'll give you the rest of the day to get your closing arguments ready. I'm imagining that you don't want to argue tomorrow morning at 9 o'clock. Is that fair?
That's fair.
Mr. Brennan, are you in agreement?
I'm in agreement. I'm not interested in arguing tomorrow.
Okay. All right. So we'll give you tomorrow.
interested
We'll
in
have a
arguing
charge
tomorrow.
conference tomorrow. I'm going to ask the court officers to call the jurors tonight as soon as possible. This is great that you did it. I was going to give you until 7 o'clock tonight, but if you're certain, then the court officers will call the jurors now and let them know they don't have to come in tomorrow. And then when they come in Friday morning at 9 o'clock, we'll do arguments and charge. Tomorrow morning will be the charge conference. Since we don't have jurors, do you all want to come in at 10 o'clock instead of 9 o'clock?
That would be great.
Does that work for the Commonwealth as well?
Yes.
Okay, so I'll see everybody tomorrow morning at 10 for the charge conference. Do you have them now, Jim?
I do, Judge. And just for the record, YYY, ZZZ, AAAA, and BBBB are 223A through D. If you want to look.
In the same corresponding order, so you know what they are, Mr. Jackson, in order, okay?
That's 223.
223.
Thank you. My only other question, Your Honor, was regarding the parameters of closing argument. Last year, we were relegated to 1 hour. I would ask.
No, I got it, but yeah, you can go.
I'll ask. I'll ask for an hour and a half for a final summation, given the case, the length of the case, the amount of evidence that's been adduced. I don't think that's the greatest, and the court normally allows only an hour.
You might get an hour and 15 minutes out of it. Let me see about an hour. Let me see. Yeah, you would not have got an hour and a half by asking for 2 hours. Mr. Brennan, what are you looking for? Do you want to see him?
I don't have a position, I'll take whatever the defense is.
And we'll think about it. All right, so we will see.
Thank you.
All right, so I'll see everybody at 10 o'clock tomorrow morning. Is there anything else we need to discuss?
No, thank you.
All right, we'll see you tomorrow morning.
All right, so court, please.
Goodbye.
Goodbye. All right, 1 second. I'm just quickly putting something in place, and then I will give you my full and undivided attention. Some of these things can be really finicky, just saying. So there we have it, peeps. The oh shit, I should finish my ham sandwich. Hang on. So the defense rests. No rebuttal witnesses. Charging conference tomorrow, and then straight into closing arguments. The jury may well have this Monday. No, from the sounds of it, they're going to Friday will be for closing arguments. Bet Bev looks like that ham sandwich. Oh, thank you, Frozen A-hole. It's not like I just stuck that in my mouth. Gross. How long does it take to eat a ham sandwich? The key to cracking the case? Well, it depends. How long's a piece of string? Are you building a model? Are you listening to evidence in the middle of a cafeteria? Who the hell knows? Oh yeah, that's a good point. Do we want to take jury deliberation estimates? I'm still fully expecting that Alessi has been frantically typing up an appeal brief, and I am praying that if it comes back with a conviction, that they just slap a 75 to 150 page appeal brief down on our desk and say, we are filing this immediately. Hoss long to eat sandwich. This is getting better and better. So, closing arguments only 1 hour 15 each, so they may get it Friday. Actually, yeah, they may start deliberating Friday. Holy crap! Imagine if we had a verdict back before end of day on Friday. Oh, I'm gonna have to work out who to trust with my phone number, because I have every intention of sleeping. Take a Dr. Wolf sandwich. I know it's unlikely, but you know, we can hope and pray, you know? All right, peeps. Well, to be perfectly honest, I'm gonna have to try and work out what I'm gonna do for my other days. So, do you think it's reasonable for this Commonwealth's appellate lawyer to be in the courtroom the whole time? Yes, that is frequent. That is something that happens fairly regularly. They're allowed to be in the courtroom just like anybody else, because he's there typing up to basically be ready and prepared. So Bev will bring him in at 11 on Friday. Just watch. Give him the weekend to deliberate on it. That could well happen. You can trust me, I'll only give it to important people. How's the family doing? Family's good. Thankfully, the child is well and truly fast asleep. Lady Overlaw'd is currently sitting in the kitchen. Actually, you know what? I'm going to give you guys a sneak preview of something. I'm not going to play the video, but I will give you some of the audio, because this is what I'm going to be working on over the weekend. Lady Overlaw'd, she's amazingly intelligent. She's a brilliant woman, and I love her to bits. And for years, she has given me shit about being book smart instead of street smart. But there's certain things, certain tidbits of information that she just cannot wrap her head around. For example, I convinced her that if she tied a sheep to the front of her car, kangaroos would stay away. Mind you, I did that after she hit 2 kangaroos on consecutive weekends and pretty much totaled her car. So that was so she could be able to drive and feel comfortable. This was our conversation 2 nights ago. Okay, hang on. I need to get this straight. Well, take the dressing gown off. You look hot as it is. So,
Stingy said, what do GF and parking spots have in common? The good ones are mostly taken, so sometimes you slip away in the disabled ones when no one's looking.
that's really bad, Stingy. All right, now no more super chats. I don't want to interrupt this. I'm only going to play the first minute of this because I took 4 different videos and there's 12 minutes worth of audio total, okay? The kangaroo horns do shit all, though. They really do. When you reach a certain speed, they put out a high-frequency, ultra-low sound whistle, and half the time I've seen them actually attract things. That first part sounded like you were under duress. No, look, it's just how bad the audio sound because I was in front of the camera, she was behind it. Okay, hang on. I need to get this straight.
Dressing gown, don't video this.
Well, take the dressing gown off. You look hot as it is.
Come on. Come on. Come on.
So, we were just talking about how you know a cow named Bruce. And then I said, well, if his name is Bruce, he's a boy.
He's a cow.
Cows are girls. Bulls are boys.
No.
Yes.
Yes. What's the other species of animals where we've had this same conversation?
Lions and tigers?
No, but
You thought lions were male and tigers are female?
No, but I swear, was it chickens?
Chickens and roosters?
Why do they give them a different name just because they're males? What happened to equality?
It goes on like that for 12 minutes. Like I said, I absolutely adore that woman, but some of the shit that comes out of her mouth sometimes. Oh, I want to do more more shows with her, but the time frame just never works. I mean, obviously, when I'm in the car, then it's not really appropriate. If I'm like, I can try and do pre-record shows, but it's about trying to find the right time to like even just sit at the kitchen table and have conversations and that sort of thing. Like she's still hard at work. Like tell her that tuna's not really chicken. Chicken of the ocean. You literally heard this conversation from a streamer yesterday? Oh, well, screw them for copywriting my life. Bruce is a lovely girl's name. No, because Bruce is legitimately a cow that's, well, a bull that has gained a massive following on social media. And we go into the whole thing about how you tell a bull from a cow, and then dairy cows from beef cattle. And it just turns into a whole thing. What's her line? Nurse? No. She is, and I'm extraordinarily proud of this, she is a senior legal assistant and practice manager for a personal injury firm here in Melbourne. She is literally at the top level of where she can be and what she does, and I'm incredibly proud of her. I really am. Bruce wants to be Caitlin. Never milk a bull. Oh no! When I put that to, because I'm gonna use the koala emotions with the moving mouths. When I do that, I'm slicing in that clip from City Slickers 2. I tried milking your cow this morning, but I got very little milk. His name is Norman. You were pulling on his dick. I'm so splicing that in as many times as I can. So. Wait till she hears about Rocky Mountain oysters. This is true. Oh, what are you sending me now, Stingy?
Why is Bill hating on women so much? I'm not. I love women. Guys, if I hated women so much, why would I be playing as a woman right now?
Good one.
Well, she is a girl. Yeah. How do I know if a cow's a girl?
Oh my god. Okay, so someone else did that too. That's funny. Anyway. All right, guys, it's 11 o'clock. I got to drive in the morning, and I've got to work out what the fuck I'm going to do for streaming for the rest of the year. So I'm going to leave it here. Thank you so much for joining me and keeping me company. As always, please remember, you are not a piece of shit. You have value and do contribute to society. Oh, and for tax purposes, this thing is really making the rounds. It's almost there, and I've got fucking bits and pieces and things to go that I'm for tax purposes. Thank you so much to everyone that has sent through super chats, and thank you, maybe not, if you're watching this on the replay. Thank you very much for the memberships earlier today. But as always, people, smack that like button, double check whether or not you subscribe, because let's face it, I am aiming to break the YouTube curse. I have been at 30,600-ish for the last 2 freaking years, because I go up, and then YouTube goes down. Thank you, YouTube promotions. I am never going to get over that. But anyway. As always, stay healthy, wealthy, wise, and I'll catch you all on the flip side. Cheers, peeps.
And again, on your way out, please do me the favor. Hit the like.
Shit, I forgot. Tomorrow, hopefully, provided I can pick one up, I'll be doing a Cigar Lounge stream this time tomorrow. Peace out, peeps.
And again, on your way out, please do me the favor. Hit the like and subscribe button if you're so inclined. It costs nothing. It's absolutely free. And we'll be friends forever. Bye now.
This shit, I'm out. Fuck this shit, I'm out. No thanks. Don't mind me. I'ma just grab my stuff and leave. Excuse me, please. Fuck this shit, I'm out. Nope. Fuck this shit, I'm out. Alright then. I don't know what the fuck just happened, but I don't really care. I'ma get the fuck up out of here. Fuck this shit, I'm out.
Fuck this shit, I'm out. Alright, so let's see. So I need to put A in slot A goes into tab A goes into slot B. That means up B. 8, 9. Oh shit, did I put the wrong ones on? No, I didn't. Okay, so that's 5 and 8 and 9. I can at least get these ones done before I There's so many fucking critical. You go like That's just stingy. One that looks like a house. So it is these ones. That, which is great because it means that I don't have to worry about those stickers being loose again because I was a dumbass and managed to put them off before they were ready. Really cool. Huh. One of these days, it's going to cause me some real problems.